Now, as I talked to my boss, Richard, who was the 12-year-old up here whispering, and you hear everything he was whispering. Now, I have to tell a little story on that. He goes, okay, we're going to be the first ones out on the seminar. We're going to work hard on it. And now, there's one thing that bothered me through that whole process was in those 3,000 pages of information. I want to ask you, how many of those pages did he actually read? Do you guys know?
No, actually, it's been a lot of work. It's been challenging. But you can tell this is really complicated. She covered so much material. I mean, she could have probably talked for 3 or 4 hours just on her subject. Yep. Now people are coming up to me going, okay, I'm really confused. Well, this next segment, we're going to spend time and we're going to drill down to just the pay or play tax. Because when you go back to your company and your chief financial officer says, okay, are we going to pay the tax? Or are we going to continue with our health plan? Jim and John are going to spend time. John's going to talk about which employers are going to be subject to the tax. And then Jim's going to talk about the actual taxes. How do you calculate the tax if you don't offer a plan? And he's also going to talk about the tax if you don't provide a plan that has the 60% minimum value. So I'm going to turn it over to these two. And at the end of our presentation, we've actually tried to prepare a worksheet where you actually go through the numbers and you can show the financial people this is what it's going to cost to either continue our plan or drop our plan. With that, I'm going to turn it over to John Paparonis.
Thanks, Bill. The whole player pay analysis begins with a threshold question. And the threshold question is, are you an applicable large employer, which is a defined term? And basically, an applicable large employer, make sure, there we go. An applicable large employer is an employer that has an average of more than 50 or more employees in the preceding calendar year. But now, so it's for a lot of you, you'll be clearly over 50 employees and way over 50 employees. And so this part of this threshold question, you'll be beyond that, and you go directly to the part of the analysis that Jim will be talking about, which is actual calculation of the penalty. But for a lot of you, when you're closer to the 50 employee range, this will be really critical. Just the determination as to whether you are an applicable large employer will be critical, and getting to that number is as you'll see, is somewhat complicated. Now, before we get to just the definition of applicable large employer, there's kind of a pre-threshold question, which is, who is an employer and who are their employees? And that would sound like a very simple question. An employer is defined in the statute to be the person that or the employer of an employee under the common law test. But there are a couple of implications to this that are really important, and I think these are going to be the two take-home points that you need to think about. One is you need to think about, in employee benefits, a lot of times the question comes up is to whether an employer is classified an employee properly or whether they're an independent contractor. And since we're talking about actually calculating the number of employees and whether an employer has 50 employees, you can see that the determination as to whether a worker is an independent contractor or not is going to be really, really important. So I think again, this is a really important point. If you have independent contractors, you need to have a really good determination, a really strong determination that person is really an independent contractor and not an employee, because that determination will affect whether that person goes into your calculation of applicable large employer. Secondly, employers, for this purpose, like a lot of other purposes in employee benefits, like retirement plans and other tests, is determined on a control group basis, which means that if a company has several entities and they're commonly controlled, which is generally the same 5 or fewer people own 80% or more, then they're considered to be the same employer. So keep in mind as I go through these next couple slides that this is based on a control group basis. The fact that you have separate entities that you may own different percentages of needs to be looked at. And again, like I said about the independent contractor determination, you need to have a good determination about what the control group analysis of your entities are, so that you are sure that you're not leaving somebody out that you think is not part of your employee group. Likewise, the rules also apply to affiliated service groups. And these are a really technical area of determination of an affiliated service group is generally 2 or more groups where there's some common control, and some of the one group may provide services to the other group or to common clients or customers, and there's some really complicated rules. It sometimes comes up particularly in the case of medical services, but it can come up in other situations. But this is another situation where those are considered to be one employer. So again, that's something to keep in mind, and just don't assume that just because you have different entities that may not have 80% common ownership, that you still may have an affiliated service group. And finally, the third criteria. Let's see. I'm sorry. I was on the wrong slide there. The third criteria is that an employer includes a predecessor employer. And we're not exactly clear yet as to how the regulators are going to interpret that. But there's the thought behind that would be, in some situations, for example, if a company is buying the assets of another company and continuing the business, and that the company that they bought the business from, some of those employees are coming over, there's some question as to whether those employees should be counted as part of this calculation, because the successor employer is the employer of those employees. And so that's something that we're going to need to get more guidance from the regulators when they issue regulations. But that's something to keep in mind. Now, as I said, the second bullet there is the base definition. Applicable large employer is an employer with 50 or more employees in the prior calendar year. And a full-time employee is considered to be an employee who works an average of at least 30 hours per week. If you have part-time employees, someone that works less than 30 hours a week, they're not considered to be full-time, but so they go into another part of the analysis, which is the full-time equivalence, which we'll talk about in a minute. And then finally, I want to mention on this point that the IRS is thinking about the case of employees that are in their waiting period and whether those should be excluded from this calculation. So if you have a 90-day waiting period, excluding those employees from the calculation of number of employees. Okay, as you might expect, the determination, when they got these mathematical tests, basically, for determination, the devil's going to be in the details. And so the IRS, Robin mentioned this in session number 1, has issued a notice to talk about the things that they are considering putting in their final regulations as to how to determine the full-time employees and how to count hours. One of the things that they're considering is that they're deeming to be a kind of a safe harbor that if an employee works 130 hours a month, that's considered to be full-time, that they're working 30 hours a week. As Robin mentioned previously, for hourly employees, it's what they're thinking, and this only makes sense, is going to be based on hours worked. For non-hourly employees, they think that they're going to have 3 possible rules. One is actual hours. The other is a day's worked equivalency, so that you assume that, for example, that if an employee works 1 hour during the day, they would get credit for 8 hours. And then finally, they're considering a week's worked equivalency, where if, say, a salaried employee is working at least 1 hour a week, they would get 40 hours of credit for that purpose. Okay, the determination of applicable large employer is really a very simple mathematical equation. It's just A plus B. A is the number of full-time employees. B is the number of full-time equivalents. And you determine each of those on a monthly basis for the prior calendar year. As I mentioned before, the number of full-time employees is any employees employed at least 30 hours a week in the prior calendar year. And if an employee doesn't meet that, they go into the full-time equivalent calculation. Okay, getting a little bit more specific, for full-time equivalents, you count each full-time equivalent as one employee. But there's just two basic steps in calculating full-time equivalent. Number one, you calculate the aggregate number of hours worked by full-time equivalent employees, and that's but not counting any more than 120 hours for that employee. And then, step number two, you divide the total by 120, and that gives you the number of full-time equivalents. So, for example, if you had 60 part-time employees, and they're working 20 hours a week, and they work four weeks in a month, that gives you 4,800 hours. And if you divide 4,800 hours by 120, that would be step number two, that gives you 40 full-time equivalent employees. When you're doing that calculation, you may start thinking about, what about, I have some seasonal employees. What about the seasonal employees? Surely that doesn't go into the calculation. I just have them for 2 or 3 months of the year. Well, the answer is the seasonal employees do go into your calculation, both in the full-time employees and the full-time equivalents. But the IRS is considering a special exclusion rule, so that if you exceed the 50, if you go through those two steps in the prior slide, and you calculate that you go over, and you include the seasonal employees, and you go over 50 employees, your result yields more than 50, but you're going over 50 because you have seasonal employees who work less than 120 days, then you can exclude those seasonal employees and go back under the limit, the 50 employee limit. So seasonal employees will not necessarily cause you to exceed the limit. And just as an example how that might work, if for example you're a company that has a retail store and you have 30 full-time employees, but you usually hire an extra 30 employees during the Christmas holiday season, and assuming that Christmas holiday season is less than 120 days, then under this contemplated exclusion, those seasonal employees would be excluded, and so you would not be an applicable large employer. Okay, now this slide gives you the final steps in calculating the applicable large employer. I mean, basically, you calculate the number of full-time employees, then you calculate the number of full-time equivalents, and again, we're including seasonal employees in both those steps, and this is for each of the 12 months, and then you divide by 12. And if that average number is 50 or more, then you have to go to the next, the penalty analysis, which Jim will be talking about, if it's, unless you can use the seasonal employee exception. And if it's less, then you're out of that analysis, and you don't have to go to the next step.
Thanks, John.
Yes.
Oh my. Never knew it was going to be so hard to determine whether I had 50 employees. But I think what we can take away from that is if you've got seasonal part-timers, the rules are complex, and they're talking about amending these rules, and have a lot of clients that are in a seasonal business. You're going to have to really drill down, because if you make a mistake and you don't handle this properly, you're going to be subject to some very stiff taxes. Especially, I have a lot of employers who have skirted those issues on whether or not employees are independent contractors. Now, it's very important to get a good handle on whether those independent contractors are truly your employees. A lot of complexities in the PEO world, and we're not even going to cover that today. But I'm going to turn the rest of the program for this session over to Jim Prince. This is the meat. This is the important part of what you really need to know. Am I going to pay this tax? How do I calculate the tax? Am I going to be subject to a tax? And again, it's very complicated, but this is the area that you really need to understand and be able to go back to your employer and communicate how this tax is going to work. I'll turn it over to Jim.
We're not used to these lights here, by the way. And for the people on the front row, they may be getting some reflection off some of us. So bear with us, all right? I asked Brad if we were going to get some makeup or something, but the last time I asked him something about that, I asked him, he somehow has some computer program that can put different Photoshop, I think it is. And one time they took our photos for the film for our firm directory, and he said, "Anybody want any touch-ups?" And I said, "Yeah, I want more hair." Well, he finds somebody in our firm, and he takes their hair, makes me look like Stalin. I mean, seriously. So the thing is, beware of what you ask for. Now, that has nothing to do with what we're talking about here, but I just wanted to let you know. Anyhow, John's told you the complexities of trying to determine what Bill said. You never knew it was so hard to determine whether you had 50 or more employees. But assuming that you do have 50 or more employees, let's talk about the taxes that can be imposed on you, and these are avoidable taxes. So, they're may be called penalties, but they are avoidable, and there's two of them. There's two different levels. We've got one level that is what we're referring to as the no coverage tax, which applies to an employer that doesn't provide a health plan to some or all of its full-time employees. And then we've got what we're going to call the inadequate coverage tax, and that tax is one that applies to an employer who provides a plan for its full-time employees, but the plan is either doesn't provide the minimal values that Robin was talking about, this 60% actuarial value. And if you think lawyers can turn you into zombies, wait till you start getting your actuaries in here. So anyhow, the 60% actuarial value, so if you have a plan that provides less than that, or if it's not affordable for your employees, then this second, which we're going to call inadequate coverage tax, may apply to you. So let's take the first one, the no coverage tax. It applies, again, if you're an employer and you have employees for whom you don't make coverage available. Full-time employees who you don't make coverage available for. If you have any of those, then this no coverage tax will apply to you. As I said, the minimal essential coverage, if you have a health plan now that is a run-of-the-mill health plan, not a mini-med plan, not a limited indemnity plan that only covers hospital stays, not the accepted benefits that like dental only or a vision only. But if you have a broad-based health plan that's being offered in the market, then it's going to be the kind of health plan that will satisfy this requirement. Now, it may not satisfy all the requirements for that inadequate coverage tax, but it will satisfy the requirements and help you to avoid this no coverage tax. So if you have that plan and you provide it you make it available to all of your employees, all your full-time employees, then the tax does not apply to you. Now, if you don't, then the tax does. And let me see if I can get this to work, because I'm not experienced at remotes, because I hardly ever get to touch it at my house. And because it's always on the Desperate Housewives of somewhere. Anyhow, this tax, this no coverage tax is pretty onerous. It's $2,000 per employee per year. Now the calculation is actually, we've got the formula set forth there. You take your full-time employees, subtract 30, and multiply it by the $2,000, or on a monthly basis, the $166.67, which, if our math is correct, is 1/12 of $2,000. And that is the monthly tax that you will pay based on it's based on all of your employees, including employees who are being covered. Okay? So it is truly a driver to get you to provide a plan, to make a plan available. Because even if you have the greatest health plan in the world and you pay 100% of the costs, if you have full-time employees who aren't offered coverage, then you're going to get hit with this tax, and it's going to be based on all of your full-time employees, even the ones that you're providing that great coverage for. So the key thing is have a health plan to avoid this. Have a health plan and make sure that you've got all of your full-time employees eligible. Now, that sounds pretty simple, and it is, if you know who your full-time employees are. So you've got to first go through this horrendous analysis that John was talking about seasonal and part-time and all that. But more importantly, and this is one. Imagine that Bill is your parent, okay, and once you're over that okay, imagine that he's standing in front of you and he's got you by the shoulders and he's saying, "Listen to me," okay. So this is what he's telling you. He's saying you've got to identify. You've got to be sure that somebody that you're treating as an independent contractor is truly an independent contractor and not an employee. Because think of what happens if your health plans probably have a fail-safe provision in them that says we're covering employees, and even if you're an independent contractor, we're not going to cover you. Even if we've misclassified you, even if we've classified you as an independent contractor, but you're really our employee, then we're not covering you. Now think about what that does to you in terms of this no coverage tax. That person is an independent contractor. You've classified it as independent contractor and haven't made coverage available to them. And you've got 10,000 other employees that you're providing the greatest plan in the world to. You got this one employee or this one independent contractor. It's a software engineer that You're doing it as accommodation to them. They always want to be independent contractors. So this one person, the IRS comes in, and the IRS has been looking at independent contractor situations lately. They come in and they say, oh, this guy, you control what he does, you provide him the workspace, you do all the things that make him an employee. He's your employee, okay? You've got an employee that hasn't been offered a health plan. Boom, you're paying $2,000 a year for all 10,000 of your employees. So that's the one thing. That's the one thing that Bill's got a hold of you, and he's telling you. Make sure you've got your independent contractors properly classified if you use it. The other thing is, and he hadn't let go yet, he's saying, and I mean, this is a big guy. He's got a hold of you, and he's saying, okay, now that you got your independent contractors figured out, make sure you understand who's in your control group. Now, and John mentioned that too. Control groups are companies that are owned commonly or owned by each other. And where we find this to be a problem is you've got an owner who's got a restaurant business and also got a bank, okay? And the bank people don't know about the restaurant business, okay? They've got their own plan, and you've got or you have a family that owns the bank, and one of the members of the family owns the restaurant, okay? So the bank has a great plan. They're doing everything right. They don't know about the restaurant. There's employees in the restaurant, full-time employees. They're not, and let's say that there's 25 of them. So they think we're not an applicable large employer. We don't have to have a plan. They're going to be aggregated with the bank employees. The bank thinks it has done everything right. IRS comes in and says, okay, we want to know what common ownership you have. They find out about the restaurant. You've got employees there that aren't being offered a plan. Again, $2,000 a year that you could have avoided. And you're thinking you have avoided it because you're the bank and you've provided that great plan. So those two things, again, visualize Bill standing in front of you, grabbing you by the shoulders, saying, listen to me. We always listen to Bill. The next tax, then, the other avoidable tax, is the inadequate coverage tax. This tax is the one that applies if you have people, you're providing a plan, you're providing a health plan, it meets all the requirements, but it's either not providing that 60% actuarial value that Robin was talking about, or it's not affordable. And it's not affordable. This is getting to it costs the employee more than 9.5% of their household income. Now, there's the safe harbor that Robin mentioned this morning is you can use the W-2 income as a basis for determining that. But this tax applies if you have employees. You're providing a plan, but you have either your plan is not providing the sufficient actuarial value, and most plans are going to do that. As she said, most plans, 60% is a pretty low threshold to reach in terms of a health plan. But it may not be affordable. You may have people who aren't affordable. And so they're able to go into the exchanges that she talked about, and they get a credit or they get a subsidy from the exchange. And if that happens, then you pay a tax based on that person. But it's only based on the number of people who it's actually not affordable for and who go into the exchange and get the coverage. It's not based on all of your employees. So that penalty is $3,000 per year, but it's only the specific employees who the coverage is not affordable for and who actually go to the exchange and get coverage and receive the the subsidy from the exchange. So again, now, and it sounds worse. It's $3,000 a year, but again, it's only those employees who get that, who actually do that, not all of your employees. So we've got the two levels of tax, two different kinds of tax. And by the way, that tax, if you're worried about it somehow, there's a cap on it. You never have to pay more than you would have paid had you had to pay the no coverage tax. So basically, to summarize, this is that some of us have to get really simple. No plan, you're going to pay a lot of tax, probably. You're going to pay a tax based on all your employees. Crummy plan or an unaffordable plan, you're going to pay a tax, but it's going to be potentially far less. So that's the summary of the tax the tax calculation. Now we've got an actual calculation, and it's in it's under tab 4.
Right.
That we go through. We want to go through to show you how this applies and what you might do. I mean, if you're considering, well, we'll just drop our plan. Do you really want to do that? I mean, we've had people talk about that, and we've said, it may be worth it if the tax is only $2,000 a year per employee. Maybe it's worth it to get out of the healthcare business and not have to worry about COBRA and HIPAA and all that stuff. Maybe we should just do that. Well, and that may be what you want to do, but look at this analysis. I don't know. Can I get it on the screen?
No, you don't have a slide, Jim. You're going to have to.
You're going to have to look at the book. It's in the book. It's at tab 4. So, what we're assuming here is we got an employer that's got 1,000 employees, and we're really just talking about 600 employees that we know as in order to hire them and keep them working, we got to provide them health care. Or we know that they're going to get health care, and they're going to they're valuable employees, so they're going to get it somewhere, and they are expecting their employer to pay for it somehow. Okay, so let's say we've got 600 of those people. We got 1,000 employees, but we have 600 people. In the first column, we start with a cost of coverage, and let's say that our cost of coverage, the premium is $6,000. So whether they pay it or we pay it, the cost is $6,000. Now, let's say then that in order to give them, we're going to give them money rather than provide a health plan. And so in order to give them enough money where they can go buy their own health insurance, go to the exchange and buy it. If it costs $6,000 to buy that insurance, then we've got to pay, that employee is going to pay income taxes on that $6,000, and they're going to pay additional FICA on that $6,000. And then they're also going to, and if we give them money to pay the extra tax and the extra FICA, they're going to pay extra income tax and extra FICA on that. And ultimately, that gets you to provide an employee, and we think we're pretty close on this calculation.
Pretty close.
We've made some assumptions, but that gets you an employee. In order to get an employee a $6,000 worth of value, you have to pay him $9,600 because of the tax, because the additional taxes that are paid that are not paid if you, as the employer, are providing that benefit.
Now, Jim, it is important to point out also that if they go to the exchange, they can't pay with a pre-tax basis.
Right. They're not paying. They're paying with after-tax money. Okay. Whereas you're providing it to them on a pre-tax basis, and that's why that difference is here. So, per employee, we're now paying $3,600 more. Now, go down to the next section where we say additional costs to the employer. We've got $9,600 that we're paying to our employee. as additional compensation. Now, the employer then is going to pay additional FICA itself on the compensation, on this additional $9,000 that it's paying to its employee that it would not otherwise pay. So we've got another $736 that you're paying for just to have that, to keep that employee in the same position they would be in if you were providing them with this $6,000 benefit. So now we're up to a total of $10,000 if you're not providing it, whereas it costs you $6,000 if you provide it through a plan. So we've got a difference per employee of $4,300 roughly. If we've got 600 employees that we're doing that for, then we've now got an additional cost of $2.6 million that we've now incurred simply by getting out of the healthcare business. Just by doing that. Now, in addition to that, if you'll flip the page, and it's on the back, then we've got the tax. Then we've got the no coverage tax that we're going to have to pay. Okay? And in this case, then, we got 1,000 employees, and we're going to pay $2,000 per year. So this is the calculation. Remember, we take the total employees on this no coverage tax. We take the total employees and subtract 30. And I'm not sure where the 30 came from. It's a break that the government's giving you. But you get to subtract 30 from this calculation. So that leaves us with $970. We got $2,000 a year. That's an additional $1,940,000 that you're paying. So adding those two, adding our $1,940,000 to the $2,006,000, the cost then in this example of getting out of the healthcare business is $4.5 million, and that's on basically covering 600 employees. So it isn't as easy it's not as simple as saying, well, if we're only going to pay $2,000 on this no coverage tax, why don't we just get out of the business? Why don't we just stop providing a benefit? The problem is, if competitively you've got to provide health care in order to attract and retain your employees, you're going to have to do something. You can't just pay that tax. You're going to have to provide them with a benefit, and if you provide them with a benefit outside of a plan, it costs you a lot more. So that's sort of the analysis, the nitty-gritty analysis. Now, there are a couple of additional issues that we wanted to include as part of this, and that is the new waiting period restrictions. And this kind of flows into the penalty tax because it does impact you in terms of who do you have to cover or who do you have to count and how do you count them for purposes of both determining whether you have 50 employees, but also how do you determine this tax. So waiting periods, first of all, just to make sure we're on the same page, waiting period is the period after somebody becomes eligible for your plan that they have to wait. And typically you have a waiting period, 30, 60, 90 days. Beginning 2014, the maximum waiting period is 90 days. So you can't have greater than 90 days. That requirement's going to kick in January 1, 2014. Keep that in mind, and that's for plan years that begin then.
Now, Jim, can we clarify that? Because I have a lot of clients who say, well, I have a 90-day waiting period. Well, sometimes it's a 90-day waiting period, then you enter at the following month. So you can actually stretch that on all the way up to almost 120 days.
Yeah.
So you can't say 90-day waiting period in your plan. You got to make sure the total period of time does not exceed 90 days.
Right. So the plans, we've got to worry also about what plans are covered. we're looking for actually greater detail in terms of that. But keep in mind that it certainly refers to your group health plan. Probably applies to cafeteria and FSAs. The accepted benefits probably not. So now, question I've got there at the end there: how does this waiting period fit into the player pay tax? In other words, how do you if you have somebody that you've just hired, you have to count them. I mean, do you if you have a waiting period, does that mean that person doesn't have coverage and you're not providing a benefit, so that you get hit with the no coverage tax? The answer is if you satisfy the waiting period requirements, no. If you have a valid waiting period requirement, not more than 90 days, then those folks, you don't have to provide coverage and in order to avoid the tax.
But let me ask you a question,
Yeah.
Jim. Back on your calculations, if I manufacture widgets and I can get anyone to work for me and they're part-timers and there's no skill, that analysis that you went through is not going to be as important.
Well,
correct?
it may not be. There may be situations where, rather than being in the healthcare business, you don't care.
Yeah.
You'll pay the $2,000 a year.
Right.
If you can hire all the people that you want, that in other words, you don't need it in order to attract and retain your employees. You don't need to provide a plan, or to provide them with the financial capability to go buy their own plan. If you don't have to do that, then that analysis, that it may be that you do want to get out of the healthcare business. I think that's going to be the rare employer that applies to, because even though you've got some people that manufacture widgets, you're also going to want to have a plan. You're going to have some of your key employees. So I'm not sure what employer it is that's going to be able to completely get out of the healthcare business. And then once you're in it, you've got all the complexities. You've got all and then on top of that, you may be paying an additional tax. So
there's 7 or 8 of us that work for McAfee Taft doing benefits. 80% of what we do is correction of problems. Now, how are employers? Tell me how employers are going to comply with these rules and regulations and calculate the taxes and.
I think happy hours are going to be. That's where you need to invest your money. I think that's where we're going to be. We need.
So what's
either happy hours or religion, and probably a combination of them both.
Right.
All right.
Okay.
No, I think this is hugely complex. I mean, you all listen to Robin, and she's sort of on the cutting edge of a lot of this. Right. She knows. We've studied it. It truly is I'm not quite 3,000 pages. I think we counted it 2,700 pages. If there's someone around other than Richard Nix that's read it all, I don't know who they are. But it's hard. I mean, it's hugely complex. I don't know how you all. I truly get a headache trying to keep it all together. I mean, there's so many moving parts here. There's some other complexities that we haven't talked about. I mean, for example, we talked about the independent contractors. Well, if you make that, let's say, okay, you decide we got some independent contractors, but we're going to be safe and we're going to pull them into our plan. All right, we're going to provide them with health care coverage. Well, the Department of Labor and the states have this concept called a multiple employer welfare arrangement, a MIWA. Okay, and a MIWA is a plan that covers employees of multiple employers, kind of like the name sounds. Okay, MIWAs, generally your plans don't have to worry about state regulations. MIWAs are exceptions to that rule, which means that the state can regulate a multiple employer welfare arrangement, and some states do, including the state of Oklahoma, and they treat them like insurance companies, so that if you have a MIWA, you have to file with the insurance commissioner's office. You got to post a bond. You got to get a license from them, and they regulate you as if you were an insurance company because you're taking on risk for multiple employers.
Plus, you got to file a special return, and if you
have
don't
to file
file
a
that
special
return,
return.
it's a $1,000 a day penalty.
So my point is, if it's not as easy as saying, okay, let's pull in all the independent contractors we have, and that way we're safe. Well, then you got this other head that jumps up from this machine that is looking at you, and it's saying, uh-oh, now you're a MIWA, you got to you're regulated by the state, and you got to file special reports with the Department of Labor. So it's not as easy. I mean, you got to get that answer right, and that's why I say, think of Bill standing in front of you, holding your shoulders, just like he did with his children, and saying, "Listen to me." All right. Thanks very much.